Good afternoon and welcome to the Fundamentals series. My name is Patrick Shepard. I'm very pleased to be joined today by Cheryl Kane-Piasecki. Welcome, Cheryl.
Thanks very much, Patrick.
And today we're going to be talking about the seeking employment rules in the sort of context of truth or fiction. We're going to try and dispel some myths around seeking and negotiating for employment. Before we get into that, though, I'd like to share a few announcements. Today we are broadcasting from a temporary space. We're having some work done on our studio space, and we will be back next week with some tips for instructors. So if you are a stand-up instructor or you otherwise deliver ethics training as part of your ethics program, please do join us next Thursday at noon, where we will be discussing some best practices for instructor development and instructor preparedness, and maybe give you some strategies for feeling more comfortable in front of a room. We'll also be back on the 20th, 21st, and 22nd with our post-employment massive open online course. So we've not done a lot in the way of post-employment during these video broadcasts, and we're looking forward to bringing you 3 days of post-employment instructions, so look for that as well. We are going to probably run the entire 90 minutes today, so we're not going to have time for a Q&A, and also we have some sort of technical issues here as well in our temporary space. If you do have questions, please feel free to email those to us. We'd be happy to get back to you. And again, we will be back next week with our full functionality, so we thank you for your patience. And with that, I'd like to turn it over to Cheryl.
Well, thanks very much, Patrick. As Patrick mentioned, we're going to be doing a massive open online course later this month on post-employment, and so we thought that it was appropriate before we talk to you about post-employment to bring you up to speed on seeking employment, as those two kind of go hand in hand. Before we get started in the slide deck today, we did give you some materials. We posted some materials on the MAX site. Of those materials, I mean, many of them that we gave you are really for your benefit as you're performing your work. They're to be job aids for you as you provided advice and counsel to your employees. But for today's broadcast, really, if you have the slide deck in front of you, and then we will be dipping into subpart F, and we've given you a copy of subpart F there. So whether you're using that version or your own version, just make sure you have subpart F of the Standards of Conduct handy, because we are going to be dipping in and out of that.
And it's always good to consult the text. That's sort of a fundament of the work that we do.
Absolutely. And what we're doing today is we're going to try and debunk what we think are some myths that exist primarily among employees, but for any ethics officials who are also under some misapprehension about the application of the seeking employment rules. That's all the more reason we ask you to get into the regulation, because I think, as Patrick and I have preached many times from this pulpit, we all fall victim of doing some shorthand analysis, and the way that you avoid doing that is by making sure that you're always making reference to the regulation and the language in the regulation itself. And the seeking provisions can be a little tricky, so please do have those handy. And for those of you who may have long memories, the session we're doing today is actually a reprise of a session we did back in 2013. We only have an audio file on that. It was before we went video with Google+. So we're reviving this for those folks who maybe didn't have a chance to attend that session. But I guess I'm just alerting you that if you're having a deja vu moment, we did do this presentation, or a very similar presentation, a couple of years ago, that we're reprising for you again today.
Excellent.
So without further ado, Patrick, I think we're going to go ahead and get into the presentation. And the format for this presentation is basically we have a series of statements that we've heard from employees, or questions that we've received, and we're basically going to do a truth or fiction format for these statements, and help you understand why any of these statements are true, partially true, or utterly false. So let's start with the first one here, Patrick.
Yes, I've heard this one before.
You have?
Yeah, so I don't have to worry about the rules until I'm getting ready to leave government service.
And what's your take on this one? Is that true, or is that fiction?
I think this one's going to be false. This is fiction, but I do understand where it comes from. People usually think about seeking in the same vein as post-employment.
Yes.
And they think that those must be tied to each other, but that's not the case, right? These rules always apply.
Yes, it's absolutely right. I think that folks are of the misapprehension that when you're talking about seeking, that you would only be doing in the context of terminating your government service. But as we all know, there are a lot of folks who have outside employment and outside activities that run concurrent with their federal employment. And these rules will apply to those circumstances as well. Now, Patrick, where do we find that? Where do people go to find that this actually applies to?
I think we probably want to take a look at Subpart F and look at the definition of employment for purposes of Subpart F.
Yes, we do. So if everybody could reach into your Subpart F seeking employment rules, and specifically to 5 CFR 2635.603A. And at 603A, we have a definition for employment for purposes of the seeking employment rules. And what does that say, Patrick?
Yeah, and it's right there in the second part of this definition. So it says employment means any form of non-federal employment or business relationship. So it doesn't have to be an employee-employer relationship.
Right.
Involving the provision of personal services by the employee, whether to be undertaken at the same time as or subsequent to federal employment. So it's right there.
Right.
It can be concurrent with federal employment. It could be an outside activity. So that's an important thing for us to remember. And maybe this is an important learning point when we're talking to our employees about the outside activity rules, that in addition to worrying about those rules that apply when they're doing the outside activity, the seeking rules are also going to apply.
Absolutely. And if we continue on down in that definition, and there are a couple of things I want to point out here as well while we're here. It says that the definition includes, but is not limited to, personal services as an officer, director, employee, agent, attorney, consultant, contractor, general partner, or trustee. And I think it's important to note here, clearly if you have an employer-employee relationship, employment, this is going to apply. But we're extending it to other personal services in other types of positions other than a strictly employee. And that includes if you're an officer of an organization, if you're on the board of directors of an organization, that would be considered an employment relationship that would be covered by the seeking employment rules. If you're a consultant.
Yeah, that might be another myth that we can sort of dispel today. You might have an employee who says, "Oh, I'm just a consultant. I don't have outside employment." Well, for the purposes of these rules, that counts. Exactly.
So we're not looking at just a purely sort of strict convention employer-employee relationship that creates or that it triggers these seeking employment rules. We're looking at, it's a much more expansive notion of what constitutes employment. So the other thing I wanted to sort of call out here is for those agencies that have prior approval for outside activities. In reading over, I had a chance to read over some folks' supplemental regs, and it appears that in many, if not all, circumstances, it talks about you need to seek approval before engaging in the outside employment. And I guess I would just sort of like call people's attention to the fact that employees can run into thorny situations and have issues under the regulations well before they actually have...
Before they begin providing services.
Or before they even have an arrangement to begin providing services.
Yeah, and I think that's really important because it's an unfortunate place for us to wind up and also for employees, for them to come to us for outside activity prior approval, and then you find out that there may have been a problem under the seeking reg that's already occurred. No one wants to find themselves there.
Exactly. So just sort of a heads up that even if you have prior approval for outside activities in your education and training, you're going to want to let your employees know that they can have issues under the standards of conduct and frankly even under a criminal conflict of interest statute when they're going to consider engaging in an outside activity, and that they should come talk to you, whether they're required to actually fill out the form and get the actual approval. At that point, they should at least be coming to you and seeking advice from the time that they begin seeking employment.
Yeah, absolutely.
Okay, so let's look at the next one. The next one is the seeking employment rules in Subpart F prevent me from seeking employment with certain prospective employers. Is that true or false, Patrick?
I think this is one of those nice places where we can be surprisingly permissive in the eyes of some employees. The seeking rules, I don't believe they do this. I don't think this is a bar on seeking employment with any particular entities. Is that right?
That's exactly right. Now, I'm going to caveat this a little bit. For purposes of Subpart F, for purposes of the seeking employment rules in the standards of conduct, these rules they are not a bar on seeking employment with anyone. What they are is a disqualification requirement, and we're going to talk about that in a second. But there's nothing in Subpart F that prevents someone from seeking employment with any particular entity. Now, having said that, there are some other rules, including the Procurement Integrity Act, that may, by virtue of the way that it's constructed, prohibits employees from receiving compensation from certain entities for certain periods of time, which is tantamount to prohibiting the employee from seeking employment with those particular entities.
And I think that's always good to remember that these rules never exist in a vacuum, that we're always working within the framework or the larger ecosystem of the regulatory scheme we're subject to as federal employees. So it's always a good idea to ask yourself, while we've gotten to yes or we don't have a problem under this particular provision, are there other provisions that might apply to this specific employee or a group of employees?
That's right. That's right. And in a few slides from now, once we've had a chance to discuss the Subpart F disqualification requirement a little bit, I'm going to touch very briefly, kind of touch and go on the prohibitions in the Procurement Integrity Act. And we are hoping actually to have someone present more fully on the Procurement Integrity Act in August, but we'll touch on the Procurement Integrity Act here in just a moment. But for our purposes, let's talk a little bit about the disqualification requirement in Subpart F so that people kind of understand how Subpart F fits into the grander scheme of things. And what I'd like to do is to look at the overview of the seeking employment rules, which is at 601. So if we go to 2635.601 and we look at the overview.
Yeah, so it's pretty straightforward here, right? We said the subpart contains a disqualification requirement, right? What are we doing here? We're imposing a disqualification requirement, and it applies to employees when seeking employment with persons whose financial interests would be directly and predictably affected by particular matters in which the employee participates personally and substantially.
Yeah, so we're looking at, one of the first things we have to be concerned about here is whether or not the employee is going to be participating in any kind of matters that could have an effect, a financial effect, on entities with whom they may wish to seek employment. So when we're looking at Subpart F, there are basically two pieces that we're going to have to be determining. One is whether or not the employee is engaging or would be engaging in any particular matters that could have a direct and predictable effect on the financial interest of certain entities, and then whether or not that employee then is considered to be seeking employment, like what triggers what act triggers the seeking employment such that they have a disqualification requirement.
So if the answer to both of these is yes, then we have the disqualification requirement.
Absolutely, absolutely. So if we look at what that's said here about the disqualification requirement, what is it that the employee has to be doing that would give us pause or make us require them to recuse? They have to be
participating. Right, we have to have the possibility of participation. We're looking for whether or not there is a particular matter. So this is a particular government matter or a piece of government work that would directly and predictably affect the financial interest of the prospective employer. This is seeming pretty familiar to me somehow.
Yes, this language sounds vaguely familiar. What is this similar to, Patrick?
So it actually goes on to say here, right in the overview, the next sentence, specifically it addresses the requirements of 18 U.S.C. Section 208A. That's where we've heard this stuff before.
Absolutely.
So we're sort of expanding upon the concepts laid out for us in the criminal statute.
Right. Exactly. So I think that it's important to understand what the rationale is behind Subpart F, because what we need to understand is, whereas for other types of situations that don't meet 208, when we talk about like the appearance of a conflict, we are asked to go back and look at Subpart E of the Standards of Conduct, which is the impartiality in the performance of official duties. But for seeking employment, for things that fall short of a 208 negotiating or arrangement for employment, we don't push people back into Subpart E and say, look at the impartiality provisions to decide if there's an appearance concern. Instead, we say Subpart F is the regulation, the part of the regulation that you have to look to anytime anyone is seeking employment, even before it reaches negotiation stages. So what Subpart F is trying to do is it's saying, okay, we're going to take that same disqualification requirement that we have under 208.
Right.
And we're going to we're going to apply it to a whole lot of employment-seeking activities that occur well before you could even arguably be negotiating for employment.
Right, and that's because this is always a question that comes up when we talk about this, is, what's the line between seeking and negotiating? And the answer is it's a very difficult line to sort of ascertain.
Right.
And the seeking rule seeks to prevent us to need to ask that question. So it seeks to obviate the need to find out if technically we're negotiating, because that can happen so quickly.
Right.
I like to think of this reg as kind of a fence around a dangerous pit.
Yes.
Right? The dangerous pit is there. We maybe can't tell exactly where it is at all times, so we put a fence around it so we make sure we don't get close enough that we might fall in.
Exactly. And we, on the next slide we've given you, we tried to give you at least some sort of a visual sensibility about, how this regulation works. So subpart F, as we said, is a disqualification requirement, and it's a disqualification requirement that begins the minute a person is doing something in terms of job seeking, or they're looking for future employment, that we call seeking. And we're going to talk in a minute. We're not going to talk about it just yet, but we're going to get into the definitions of what are the events that are the triggering events that immediately cause a requirement to disqualify. So subpart F is grabbing a whole lot of really incipient stages of employment seeking and says from that point on, you're going to have to disqualify yourself from any matters if the matters you're working on could affect the person you want to get employment with. But then there's this tender area, this very tender area where subpart F bleeds over into 208. And it's when the person has begun negotiations, or certainly once they have an arrangement for prospective employment. And now we're out of regulatory land, and now we're into criminal statute land. So if you've disqualified someone way back in the beginning of subpart F, when they're only sort of seeking, and there's no question they're not yet negotiating, then they're already disqualified, and you don't necessarily have to specifically, at least with respect to their recusal, you don't have to worry about whether or not now, you have a colorable 208, because now at this stage they're negotiating.
So subpart F really asks us to put in place the necessary disqualifications, the necessary recusals, a safe distance before people begin doing anything that could be approaching the level of negotiation. So we want to make sure those things are already in place by the time the employee gets to the negotiating stage.
Exactly. So what you described is the pit we're trying to keep people out of, which is kind of that middle section, that we're doing here where those two circles cross. That's the pit we're trying to keep people out of. And so we start making them disqualify at the very outside of that subpart F circle. Okay? So why is it that we care about, how does this particular matters piece fit in all this, Patrick? When we're talking about particular matters, what are we really looking at? What kinds of things do we have to worry about people working on?
Well, particular matter is always the critical element when we're talking about 18 U.S.C. Section 208. And unlike subpart E, we're concerned with all of the particular matters. So we have the particular matters of general applicability and the specific party matters. So I think, we're talking about that whole universe of things that might be swept up under Section 208, which makes plenty of sense considering we are trying to avoid falling into a possible 208 problem with respect to negotiating.
Exactly. So when we're talking about particular matters, we're talking about all kinds of particular matters, and we're gonna revisit this periodically throughout the rest of this presentation. But we just need to make sure everybody's on the same page that the definition of particular matters that we use for subpart F is the same definition that we use for 208, which is going to include these both categories, the matters of general applicability as well as particular matters involving specific parties. Now, before we go on to our next true or false question, I just wanted to touch very briefly on the Procurement Integrity Act provisions. There are two basic provisions over and above what we require in subpart F and procurement integrity that deal with prospective or with future employment. The first one is basically just an additional disqualification requirement, and it says that certain agency officials may not participate personally and substantially in a contract in excess of the simplified acquisition rule when seeking employment with a bidder or offer in the procurement. I'm not an expert on the Procurement Integrity Act. That's why we're going to have someone else come in and talk to you about it. You might say to yourself, as a facial reading of this, well, this seems redundant of, subpart F and 208, because irrespective of whether it's in excess of any particular dollar figure, they will still have a recusal requirement under subpart F if they're working on a matter that can affect the contractor.
Right. And I think, if you didn't fall into this prohibition, if you were below the threshold, we'd still have to look at 208, right? Because the Procurement Integrity Act doesn't implement Section 208, so we'd have to look at 208 and determine if an exception applied or if we were okay to go ahead.
Exactly. So this one is separate and apart from subpart F and 208, and it does not trump subpart F or 208. So irrespective of what this particular thing says, you're still going to have to deal with subpart F and 208. One thing I did want to mention as well is part of this, there is a reporting requirement also that goes with this, which would be over and above the recusal requirement.
Right.
So that's one of the distinct pieces that you want to be aware of. The other one is the one that I referred to, which actually might have the effect of basically saying there are certain entities with whom you cannot seek employment.
Right, and that's only for officials covered by the Procurement Integrity Act. So we're talking about a subset of federal employees. These aren't rules that apply to absolutely everyone.
Exactly, and that's why I'm saying this is not in any way an exhaustive covering of Procurement Integrity Act, but just to kind of alert you to what these provisions generally say. And the second ban is a ban on compensation. And it's, in effect, says for a period of 1 year after, and there are certain designated dates depending upon what your function was, whether you were, you were involved in the award of a contract or et cetera. So different designated dates apply to different people who had different functions. But those officials are not allowed to accept compensation from the particular contractor, and then there's a dollar value that has to be attributed to the particular contract. So it's contracts in excess of $10 million if the former official served or acted in certain capacities. So it's, again, the thing that's interesting here is that it's not even a ban on employment per se, it's a ban on compensation. So it's actually broader.
Right.
Yeah,
so, if we find ourselves in these circumstances, we're talking about very big contracts and officials that would be covered by this provision. We just need to remember it's there and make sure we remember the 1 year compensation ban.
Exactly. Okay, so our next statement.
Yeah, so this is the one I think we hear a lot.
Yes.
It's like, I don't do contracting, and I think it's not just for seeking, for all sorts of ethics-related matters. I hear things like this from employees all the time. They say, I don't do contracting, I'm not in procurement, I don't touch contracts, we don't buy a lot at my agency. I'll never have to worry about these rules.
And that is just bunkum.
It's plainly not true.
It's plainly not true. And this gets us back to our nice little drawing that we had before about particular matters. So for purposes of subpart F, as we said, and it's the same holds true for purposes of 208, we're concerned about folks who work on a whole host of matters.
So these are all our articulated specific party matters, so our contracts, grants, licensings, inspections, investigations, litigation, but also all those particular matters of general applicability. So we have our rulemakings and other policy matters that affect discrete and identifiable classes. So our folks who say, well, I'm in the regs department, I don't have to worry about this stuff. Mm-hmm. Well, no, you do actually, and maybe a little more than everyone else, because the universe is bigger.
Absolutely, and I think that's the whole thing. And if you get pushback from your employees, I think it's a matter of sort of drawing their attention to the fact that would they argue that regulations don't have any substantial effects on non-federal sources, that they don't materially affect non-federal sources. I think the
non-federal sources don't feel that way.
The non-federal sources certainly don't feel that way. Or certain sorts of funding programs. I mean, whether it's a grant program or any other thing of which you're conferring monetary benefits. I mean, clearly, when you're determining the programs, like which and you're cultivating the program and you're determining the criteria. Under which anyone will be eligible to receive monies from the government, to suggest that somehow those entities who could potentially benefit from those programs don't have an interest in how you cultivate that program, is plainly erroneous on its face. So again, this is just a reminder that I think we we're very ready to immediately jump on what we think are the most imminent or obvious opportunities for, financial benefit to non-federal entities. And of course, contracts are the obvious choice there.
And I think, as ethics officials, and we'll touch on this a little more next week when we talk about training, it's easy to come up with examples that deal with contracting and other financial transactions between the government and outside entities. I think by focusing on those and training exclusively, we add to the perception that this is just for contractors. So when you train on these matters, it's a good idea to include some examples that involve particular matters of general applicability as well as specific party matters to help people understand the breadth of the requirement.
I think that's great, because I agree with you. I think we inadvertently create some of the mythologies simply because we go to the ready examples at hand, and we don't really do a good enough job of sort of giving concrete and illustrative examples of the whole universe.
Right.
Okay, our next statement.
Now, this is interesting, because I think this is instructive of precisely the reason we have the seeking employment regulation. People say, well, I can wait until I'm called for a job interview before I really have to worry about these rules. So I don't have to worry about any of this until I come back from the interview, and then I may be asked to participate in a particular matter that could affect them. And I think, like our statement so far, this one also is false.
Yes, it is. It's false, and it's also extremely dangerous. And this is one area where I think we all need to do a better job of illuminating for employees the breadth and scope of when seeking occurs, but more importantly, that one of the reasons why we pull seeking back to the earliest stages of a job search is because you can be negotiating, even as that's defined under the regulations, far sooner than I think our conventional understanding or our conventional wisdom about what constitutes negotiations would otherwise, our common sense might otherwise tell us.
Yeah, and I think this is why this area is so scary, because you can move from merely seeking to negotiating in a matter of a few words.
Yes.
If you ask a friend of yours who was employed by maybe an agency contractor, if he anticipates they'll have any openings, that person replies, I think we may have something coming up that would fit your skill set. And they said, that's great. It wouldn't happen to be in the Denver office, and I couldn't have a window office, could I? Well, you very well might have moved into negotiating in those dozen words or so. That might be an extreme example, but yeah, I think that it is illustrative of how quickly you can go from seeking to negotiating. But let's get in the regulation. I think this is one area where you really need to, I think, get yourself grounded in what the regulation actually says. And if we go to 2635.603, this is where we start getting into the subparagraphs, but B1, and I want to skip one little I, because one little I is, the negotiation. But this is important. The definition of seeking is inclusive of the definition of negotiating. So this idea that we could stop seeking and begin negotiating, that's not true.
Right.
When you're seeking, you're seeking. When you're negotiating, you're seeking. I think that's well taken. Exactly.
So we don't want to start with the negotiation phase. We want to start with what are the incipient stages of seeking, what are the first actions an employee can take where they're going to start seeking employment. So if we go to B1, 2 little I, it says, an employee has begun seeking employment if he has directly or indirectly made an unsolicited communication to any person or such person's agent or intermediary regarding possible employment with that person. Now, it says, however, the employee has not begun seeking employment if that communication was, and we've got a couple of carve-outs from what constitutes seeking employment, and I want to kind of hold those in abeyance for the moment. I want us to just focus on the things that are the triggering events. So we've said that in the first instance, it's if the employee has begun seeking employment if the employee has directly or indirectly made an unsolicited communication to any person or such person's agent or intermediary. So we're looking at the employee makes a contact.
Right.
And what are ways that an employee could make a contact?
You could make a phone call.
You could make a phone call.
You could send a resume.
You could send a resume. You could be working side by side with a contractor And you could, in working...
Make a face-to-face inquiry.
Make a face-to-face inquiry. So what we're looking at is an unsolicited communication, which can be of any sort of ilk.
An email would definitely count here.
An email would definitely count. So we're saying at that moment when you've made that contact about prospective employment, you are seeking employment. Okay, and like I said, there are a couple carve-outs, and we're going to come back to those. But for the most part, once you send that resume, once you make that employment overture, you are seeking employment. Now, if we go down to B1(3)(i), we have made a response other than rejection to an unsolicited communication from any person or such person's agent or intermediary regarding possible employment with that person. So what are we talking about now?
So someone says, we have an opening coming up. You might think about it. And you said to me, I'll think about it. I'm seeking employment then.
Exactly. So whether you make the contact, you initiate the contact, or the prospective employer initiates the contact, unless or until you reject that overture, from that moment that an initial contact is made, you are seeking employment. So when does seeking employment end then? So if it's when you make a contact or you receive a contact, you've begun seeking employment.
Right.
Then we talk about when you are no longer seeking employment. And the first instance is under B2. We say an employee is no longer seeking employment when the employee, go ahead.
When they reject the offer. So in our example, you say to me, at our company we have a position, I think you should consider it. And I say, no way, I wouldn't work for you in a million years. I reject your offer. Then I'm not seeking anymore.
Right.
Right.
Right. So, and the rejection can be, I mean, it has to be that you cannot defer discussions until a further date. So let's say, for instance, Patrick, I have someone who comes to me and says, Cheryl, we think you'd be a really good trainer for us and we'd like you to come work for us. And I say, well, I'm thinking, right now is not a good time, but I'm thinking maybe in 6 months I might be really interested.
So you're deferring the discussion now.
I'm deferring the discussion now.
Which is different from rejecting the discussion.
Exactly. So when we talk about rejection, we do mean reject. Now, a question did come up with respect to what if you just don't respond? Because I know that folks have had situations where they get an unsolicited communication about something, and I know through the various vehicles that you now have online, there are ways that you can have people sort of communicating with you an interest in you and you are just not interested. The question is whether if you completely ignore it, like you get something in your email, or you're on one of the job seeking sites or something and you get a hit, or however that occurs, and you simply just ignore it, or you trash it, or you throw it out, or whatever, and you don't respond at all. Is that sufficient?
No.
Yeah, it is.
It is.
It is.
No. To have rejected.
Well, it will constitute because what it says here is you have to have made a response,
right,
other than rejection, to an unsolicited communication.
Yes.
So the key here is that if you make no response at all,
you haven't gotten into seeking yet.
You haven't gotten into seeking yet. Okay. Now, we want to be real careful with that and not have people play cutesy and have there be some sort of,
nonverbal response.
Nonverbal response. So, so the person comes up to you in person and says, would you be interested? And you just give them this plaintive look on your face as if to say, I'd love to say yes, but I can't. And I mean, I'm being exaggerated here, but for the most part, you do have to make a response.
Right.
And if that response is other than a rejection, then you are considered to be seeking employment. Okay? So now I want to back up a little bit and talk a little bit about negotiating, because I want you all to understand and everybody to be clear about why it is. If you look at how broad our definition of seeking is, and you say to yourself, holy crap, I mean, they seem to capture The minute you give a peep to somebody about some sort of interest in future employment, you're seeking employment and you're in these regulations. Why is that? And I think that we need to understand where our definition of negotiating, and frankly how kind of vague our definition of negotiating is, to understand why we grab so much at the seeking end of it.
Yeah, because I think the wall between merely negotiating, or merely seeking and negotiating, is so porous
Yes.
and so easily crossed that we like to have the bright lines of the seeking regulation.
So if we look at B1, little I, and we say the employee has engaged in negotiations for employment with any person. For these purposes, as for 18 U.S.C. 208A, the term negotiations means discussion or communication with another person or such person's agent or intermediary, mutually conducted with a view toward reaching an agreement regarding possible employment with that person. The term is not limited to discussions of specific terms and conditions of employment in a specific position. This is not exactly a sterling example of clarity, Patrick.
No, this doesn't strike me as kind of the common sense understanding of negotiation. I think of negotiation as when we sort of get down to brass tacks and are talking about money and specific terms, but this is much broader than that.
Yeah, it is. So, I mean, it talks about a two-way communication. So we're looking at once you start getting into bilateral discussions.
Right.
And then it goes on to say, and those discussions don't have to be about the specific terms of the job that's
Right.
that's potentially in the offing.
Right.
So we're looking at, you can go very quickly, as Patrick was alluding to earlier. So you can go very quickly from a unilateral, are you interested? Yes, I'm interested, to, okay, well, let's talk a little bit about what your qualifications are. And you
Right.
start talking about qualifications, and they start telling you a little bit about what the job is all about. Well, arguably, once you've started engaging in that kind of bilateral
bilateral communication,
communication,
you're negotiating now.
You're negotiating
so it
now.
could literally be seconds between seeking and negotiating. It's still important to remember that this is a recusal requirement that's created here. So just by merely negotiating, you haven't violated anything until you go back to work and participate on a matter. But those things can take place very quickly. So we want to make sure that we know if we're really having any contact geared towards future employment, that we should abide by the recusal requirements.
Exactly. So that's why subpart F has grabbed will grab so much initial job seeking activity so that the person is clearly recused well before they could even arguably be negotiating for employment. And it's worth our explaining that to employees so that they understand how precarious it is when they're looking for any kind of employment, particularly when they're looking for employment with folks who can be affected by the work that the agency does. Okay. Next question. Oh, this one is notorious.
Oh, if we could unwrite this example.
I did a mass mailing of resumes to a bunch of different companies, so I don't have to worry about the seeking rules until I hear back from someone. The mass mailing of resumes. Patrick.
There is no exception or carve out because you sent out more resumes than not. The number of communications that you make in no way takes you out of the realm of seeking.
That is exactly right. So now here's where we're going to go back and we're going to revisit the carve-out. Remember back when we talked about the definition of seeking employment, and there were two carve-outs there that we just kind of skipped over. We're going to go back and visit that because the fiction in this example is that there's a mass mailing exception. There is no mass mailing exception.
Could you say it again?
The fiction in this is there is no mass mailing exception. The truth of the matter is that what this is trying to get at is there are circumstances where merely dispatching a resume is not going to require you to recuse immediately, but that's going to depend on the type of matter that you're working on. So let's get back into the definition of when you begin seeking employment and take a look at that carve-out. And if we look at 5 CFR, we're back in 603 B1, 2 little I, where we talked about where the employee is making an unsolicited communication, and we said making an unsolicited communication could involve submitting a resume. And then we say, except that if the communication was only
for sole purpose of requesting an application. So we're not seeking if we just ask for the application.
Right.
That's not yet seeking.
You're not yet seeking.
And now B, which causes all of the headaches and confusion.
B is the one that everybody mistakes for a mass mailing exception. It's if it was for the purpose of submitting a resume or another employment proposal to a person who is affected by the performance or non-performance of the employee's duties only as part of an industry or other discrete class. It says the employee will be considered to have begun seeking employment upon receipt of any response indicating an interest in employment discussion. So let's go back, Patrick, and refine this kind of understanding of if the resume is going to somebody
Yes.
who can be affected by the performance of the employee's duties only as part of an industry or other discrete class.
So it's about the relationship between the prospective employer and the duties of our employee.
Right.
So if the matter that the employee is being assigned to is a particular matter of general applicability, or their government duties would affect this person only as part of a class, then merely sending a resume isn't yet seeking.
Exactly.
No matter how many resumes are being sent.
Exactly. Exactly. So
One resume, 20 resumes. The act of merely sending a resume doesn't make you seeking if the kind of government work you're going to do will affect this person only as part of a discrete identifiable class.
And I think that what helps people is when we start using the nomenclature that I think people have increasingly become familiar with, which is the distinction between a particular matter of general applicability and a particular matter involving specific parties, because that's really what we're getting at here. What this provision is saying is if your employee is working on a particular matter of general applicability, those are our regulations or policies, programs, things like that, that can only affect, a discrete or identifiable class.
Right.
Okay. If an employee's working on a matter of general applicability, they can send a resume to anyone who could be affected by that matter of general applicability and not be considered to be seeking employment unless or until they hear something back.
Right.
And it doesn't matter how many those resumes are. It's not a matter of 1 or 15. It's a matter of if you're working on a matter of general applicability.
So let's say a concrete example, maybe. So say I'm working on a regulation affecting, let's say manufacturers of medical devices. So maybe a specific kind of medical device. And I submit an application or a resume to one company that makes those devices.
Right.
I'm not seeking until I hear back.
Exactly.
Because the regulation I'm working on is a regulation that would affect them only as part of a class.
Right.
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 That makes sense to me. It doesn't if it was a specific party matter and I sent resumes to everyone involved, no dice.
Exactly.
Right.
So
Off the air. The operator's trying to call you.
Oh. On the
okay.
phone.
Okay. So the issue is if you're working on if the employee is working on a particular matter involving specific parties,
Right.
then the minute the employee sends a resume, they are seeking employment. So let's say if you were working on a pharmaceutical, like an application from a pharmaceutical company for an approval of a drug or something.
Right.
That's a particular matter involving specific parties. The minute you dispatched a resume to that entity, you would be deemed to be seeking employment, and you would have a recusal requirement at that moment.
Right.
So this is only going to apply to situations where the employee is working on a matter of general applicability and they're sending a resume to that entity, and the only way that that entity is affected by their duties is through this matter of general applicability.
That makes sense.
Yeah. Now,
I understand how people get confused, but
Yes.
it makes sense when you stop and think about it.
Yes, and my understanding is, many of you may know that we have proposed some changes to Subpart F, and one of the changes that we are proposing in Subpart F is we're going to retain this carve out, but we're just restructuring it so that basically to say that you're still seeking employment when you send a resume under this circumstance, but you just don't have the recusal requirement
Right.
until you hear back, because we think that might help dispel a little bit of the mass mailing misunderstanding that people have by virtue of reading this. And the only other thing I want to say here is some of you might be saying, well, why didn't you just say matter of general applicability instead of wording it the way you worded it? And that's that, well, the seeking employment rules predated 2640, which is the regulation implementing 208, and that's where we introduced the concepts of matters of general applicability as opposed to specific party matters. So
An accident of history.
an accident of history, absolutely. Okay. So
So there's still no mass mailing exemption.
so there still is no mass mailing exception. Let's just be clear about that. There is no mass mailing exception.
And any changes we make are going to clarify that there is no mass mailing exemption.
Well, we are hoping that the clarification in subpart F will in fact do just that.
Very good.
Okay, so now we want to talk a little bit about, though, when seeking employment ends in the context of this dispatching of a resume. So we said that when you're approached by someone in some sort of way of being contacted, or you contact them, if the moment either party completely rejects the prospective employment and discussions have ceased, that's one way that seeking employment ends. It also ends if once you've dispatched a resume, if after 2 months you haven't heard back from the entity, then you are no longer considered to be seeking employment with that entity.
That makes sense. That seems like a sensible provision, because otherwise you could send the resume and you know how these things go. You never hear back. You would be seeking in perpetuity. That could be problematic.
Yeah, but conversely, Patrick, what about if you have a situation where, I mean, I know it's you hear notorious complaints about the government and how slow the government is to respond, and it's
Right.
not that they never respond; it's just they respond.
It just takes a long time.
little bit longer than one necessarily anticipates. So let's say that you have an employee who sent a resume to a company. They haven't heard back in 2 months.
Right.
They had a disqualification requirement.
It's set to expire.
It's set to expire, or they've resumed
Right.
working on the
Right.
matter, and then all of a sudden
They get the call.
or they
Right.
they get some sort of overture from the company saying, oh, we've gotten your resume and we'd like to see you. What happens then?
Yeah, I think that's very tricky, because they're probably going to resume seeking unless they reject any future discussions. And this can be a good thing to talk about from a practical and sort of program perspective, because you could have a problem. Someone's period has expired, their recusal has expired under the 2 months, and then so something kind of interesting happens where we say, okay, you can go back to working on whatever the matter was you were working on. They get very involved in that matter. They're performing critical work for the government, and then they get the phone call and they don't want to cease with the discussions. They don't want to reject this offer. Well, you put the program office in a bit of a bind, because now they have critical personnel who are once again recused.
Right.
So that's maybe a discussion you want to have before that 2 months is finished. Well, what happens if we say you can go back to working on this matter and they reach out to you? What's your plan? Because if your plan is to continue with those discussions, maybe you want to do a little more to make sure that the government program is protected from a sort of unnecessary disruption because of lost personnel.
Right, exactly. Okay, so our next question is, there are no potential conflicts if I use a headhunter. What do we think about that?
That's interesting. So we talked a little bit earlier about the notion of an intermediary. But I can see how this can be kind of tricky from a knowledge perspective. But I think generally speaking, merely using a headhunter doesn't remove all of these requirements.
That's right. This is fiction, and this goes back to when we talked about the when are you seeking employment, and we're going to go to 603C. We're going to go to 2635 603C in a moment, but I want us to take us back to 603B 3 little I, where we talk about if you've made a response other than rejection to an unsolicited communication from any person or such person's agent or intermediary. So, if let's say someone that, is interested in you is using a headhunter, The minute that that person is contacting you and making known, who they're working on behalf of, we know that is acting. There is an agent or intermediary that's involved there, and you can be considered seeking employment once you know who the prospective employer is. And likewise, if you're using an agent or intermediary. So it's the key is that there's a communication about prospective employment, and whether it's done through a third party or done directly between you and the prospective employer is really...
It doesn't make any difference.
It doesn't make any difference. So let's look at 603C, though, because that's where we kind of address the issue. And we say at 603C, a prospective employer means any person with whom the employee is seeking employment, where contacts that constitute seeking employment are made by or with an agent or other intermediary. The term prospective employer includes a person who uses that agent or other intermediary for the purpose of seeking to establish an employment relationship with the employee if the agent identifies the prospective employer to the employee, and a person contacted by the employee's agent or other intermediary for the purpose of seeking to establish an employment relationship if the agent identifies the prospective employer to the employee. So what are the key pieces there?
We have to know who the party is, right? We can't recuse ourselves from matters involving people unknown to us.
Right.
So it's kind of a practical exercise. If the headhunter has told you with whom they've been communicating, and you know,
right,
then you have the same obligation to recuse as if you had contacted them directly.
Right. But unless or until you know, or until the employee knows, then arguably they are not seeking employment because they don't know with whom this intermediary has been making communications or who they're acting on behalf of. So it really, the knowledge element is
right.
really important. Well, let me throw a couple of those for instances at you, Patrick. What if the employee knows he or she is being shopped around to a particular type of company, or a particular type of company in a particular part of the country, for example. And so the employee knows that there really could only be like not even a handful, like 2 or 3 maybe.
Sure.
Possibles.
No, I think that makes sense. If I could imagine a case where a headhunter says, we're going to shop you around to major auto manufacturers in the greater Detroit metro area.
Mm-hmm.
Well, that's not too many companies. I think reasonably I know who those 3 or 4 companies are,
mm-hmm.
and probably should recuse because at the end I think it would be easy to argue that I know or should know that say for example General Motors is probably going to be among them.
Right. Exactly. So I think that there are instances where even if you don't know explicitly the specific, if there's every reason to believe you could reasonably know who it is that is being approached or with whom you're having communications, that out of an abundance of caution, the employee really should be recusing themselves from any matters that could affect those entities. Well, what about a situation where, let's say you ask your friend, we all have friends, and we do that all the time. People try to network among their friends all the time.
Yeah.
They whether they like it, hate it, or whatever. There's material that, you might lose some friends over it, but seriously, like you go to your friend and you say, I'm tired of where I am, and I want to do something different. Could you kind of keep an eye out for me? What sort of indicia do you think, when should people worry about it? When does...
When are you... I think, if someone... It's kind of the same deal.
Mm-hmm.
If you know or reasonably should know exactly who's receiving the communications on your behalf.
Mm-hmm.
So I could imagine a case, you say to your friend, I'm looking for a job, maybe a writing job. And they say, I'll keep my eye out. Well, clearly there's no seeking yet because
mm-hmm.
we don't know who the parties are. If they say, well, I have a friend over at company X, and I think they might have an opening, I'm going to make a call to them.
Mm-hmm.
Then you probably do know. That's probably more like the headhunter, sort of making a communication with your knowledge.
Yeah, I think exactly. It's the same sort of thing. We're really still looking at sort of the knowledge piece. So I think that rather than focusing on the vehicle through which these sort of job-seeking overtures take place, it's mostly a matter of, once the employee, has some knowledge that a communication has been made with respect to prospective employment, that's really kind of the triggering event for seeking employment
Yeah,
recusals.
I think that makes sense.
Okay, this one. How about this one? This is rather audacious.
I'm leaving the government anyway. It's not like the agency can do anything to me when I'm gone.
Wow.
Wow. Well, that's
That's your kind of scofflaw, I think, sort of
Right.
perspective on the seeking employment rules.
right. And I always find when it comes to the Department of Justice and criminal laws, suggesting that you might be beyond their reach is not usually a good strategy to employ if you're seeking to avoid penalty.
Yet I think it has a tendency to make them slightly more hostile to your case. So clearly, this is fiction. And what we've provided for you here are some concrete evidence of why this is fiction. We don't want to give you a ton of examples, but we wanted to give you enough to make it clear that if you have folks who you think doubt that the long arm of the law can reach beyond their federal service.
It can and has.
It can and has. The first example we had is this former Air Force employee. This is the infamous, I think, Darlene Druyan case that we use as sort of the poster child for these types of things. She was overseeing a lease negotiation with Boeing for a tanker aircraft, and she was negotiating with Boeing at the same time for post-employment for job after she left government service. And she was prosecuted, and she suffered some fairly serious consequences as a result. I mean, she actually served some prison time. That doesn't always happen with these types of prosecutions. And she had community service and fines and whatnot. And I think another point to lay out here is not only did she suffer consequences, but Boeing suffered consequences as well.
Significant ones.
Yes, as did the Air Force. I
Right.
mean, and the Air Force got a black eye over this as well.
No, it's a terrible mess.
So there are some fairly serious consequences that occur as a result of this. The next example we have involved NIH, just because we don't want to, single out any particular department or agency, but just to give you a clear idea of the nature of the way these things come up. This was a chief of the geriatric psychiatric branch at one of the institutes, negotiating with Pfizer for consultancy on a project that he was working on as official capacity. Now, there are a couple, I think, interesting points here to make. One, look, it is a consultancy, and note how we mentioned that, a consultancy can be like an independent contractor type of relationship, but it's still considered to be employment for purposes of Subpart F and 208. The other piece here is this appears to be concurrent with federal employment. So this wasn't this was an outside activities situation. This wasn't a post-government employment type of circumstance. The next one involved the Department of Justice employee, senior trial attorney in the Civil Rights Division. Basically was engaging in an investigation of a juvenile correction facility, and he negotiated with the state of California to serve as a special master that was going to be appointed to monitor and oversee some reforms of their juvenile justice facilities. And one of those facilities that he would be responsible for doing in this new position was the very one that he was investigating while he was at DOJ.
Yeah, so I think this sort of dispels any myth that if you're going to a state or local government, these rules don't apply. It's sort of any non-federal employer.
Yeah, exactly. I mean, the fact that this is involving a state as opposed to a corporation, I think we tend to think of these mostly as being, occurring when people are going into the private sector. But, state governments have financial interests just the way other entities have financial interests. And,
absolutely.
Now, the thing that I know that occurs sometimes, some people might look at the result and say, oh, they only got a year of probation and it was a $3,000 fine. That seems more like a slap on the wrist. And we hear that a lot, do people really suffer serious consequences for this? And I guess my retort to that is, do we have any idea of what this person's life must have been like while they were being investigated, while they were under investigation, while they were being, they were in the process of being prosecuted? This person's career was...
Yeah, the harm is usually not the penalty, but the career consequences are very significant.
Right.
It can have an effect on people's continued ability to, provide for their livelihood. I think there are significant consequences even if the penalties don't appear severe.
Yeah, exactly. So I think the penalties are just kind of, the ultimate, price you pay. But I think there are an awful lot of other prices that people pay when they're prosecuted by the Justice Department. The next one we have was an associate director of an outpatient pharmacy. This was VA, the Veterans Affairs Department. Again, this was again one of those, working with contractors, working side by side with contractors, being engaged in that, and then, negotiating for employment with the same contractors that you're doing business for with the government. And that is always, rife with peril. This is our classic revolving door problem.
Right. And the thing with these, and I always, when I'm talking to employees, emphasize this, is the odds of detection are extraordinary. Because odds are you're going to leave government service and you're going to show up at work at that contractor or regulated entity or whoever it is that you've been seeking and negotiating for employment with, and someone's going to notice.
Right.
And that's how this begins. That's how these things get detected and how wrongdoing gets brought to the attention of the appropriate authorities. So this is an area where the consequences are going to be apparent and easily detected.
And this is an area that I think Congress takes a routine interest in. I mean, I think practically every Congress we have, there are new legislative proposals to increase, either the seeking employment restrictions or the post-employment restrictions because of this type of recurrence of employees, looking for livelihoods with the very entities that they're doing work with, and it's just the perfect opportunity. I think.
I think there's a lot of perception that this is very problematic. That this really does, these kinds of situations really do negatively affect the efficiency of the service and the effectiveness of the government and the impartiality of employees. So I think that it's an area of great attention.
Right. Right. And then the final one I included in here just because it's more recent. This, I think, was in our 2013 prosecution survey. And this was a FEMA employee. It was a HR director. And this involved a training contract. And it was with Gallup. And some of you may remember this. I remember hearing about this in the news. And the HR director engaged in negotiations with Gallup while he was requesting and receiving additional funding for the contract that they were working on. And 2 years probation, a $40,000 whistleblower settlement. So there was a separate whistleblower issue that came up, and then significantly barred from future government contracts. So. Right. So that's another way that employees can suffer consequences for engaging in conduct that violates either the regulations or the criminal statute. And one thing I did want to sort of before we get to the next truth or fiction question, which gets into the subpart F and the Section 17 of the Stock Act, when it's our final question. One thing I did want to really underscore with everyone is being very mindful of the distinctions between the subpart F provisions that are pre-negotiation and once you get into negotiation and you're into 208, when it comes to how you remedy those conflicts. Clearly, subpart F requires recusal in the first instance, as does 208.
Right.
So the question then becomes, well, what if you want the person to continue working on the matter?
Right.
So if an employee has not yet begun negotiating, and it's abundantly clear that the employee is not yet negotiating, then the agency can give an authorization, which is a regulatory authorization,
right,
to allow the employee to work on the matter while they're seeking employment.
But we have to be absolutely certain that the employee here is merely seeking.
Yes.
And as we've said a number of times today, that barrier is permeable and sometimes difficult to describe.
It is. And for that reason, I would advise you to use extreme caution whenever, if ever, you decide to give an employee an authorization to continue to participate in a matter while they are seeking employment. Because once they begin negotiating for employment, your authorization is no longer going to be protecting them. Once they've entered into what could be defined as negotiations, they are now in 18 U.S.C. Section 208, And in order to continue to participate in that matter, they're going to need a 208B1 waiver. And a waiver is distinct from an authorization. And the two should not be confused. So if you're issuing a Subpart F authorization is not going to help an employee once they've begun negotiating for employment. At that stage, they would need a 208B1 waiver.
So I could think of maybe an example of how this might come up. I could see a case where an employee has submitted a resume to an organization or company that's going to be affected by some proposed duties. And it's been a while since they heard anything, and in fact, none of us think that anything is going to come of this. The inclination is that this probably won't result in an employment negotiation, but 2 months haven't elapsed. So we said, well, 2 months haven't quite elapsed, so you're still technically seeking, so we're going to do a Subpart F authorization. And that would be fine. But the danger would be that if they receive the phone call from that organization, and they did anything really but reject the offer of employment or the discussions for employment, they're probably negotiating, right? Because now we have bilateral discussions with an aim towards moving towards employment. So they said, we'd like to schedule, we'd like to tell you some information about the job and maybe schedule an interview. Well, now the Subpart F authorization probably isn't good, and we would probably need a B1 waiver. So if we were going to do the F authorization in the first place, it's very, very important to make our employee aware of what the corners are, and when they need to resume recusing. Right, exactly. And that's the danger in a Subpart F authorization.
Now, the other piece of this, and this is just sort of FYI, agencies, you all have the authority to issue B1 waivers. And, when you issue a B1 waiver, where practicable, you're supposed to consult with the Office of Government Ethics. But at the end of the day, that authority resides with you. If you decide that you want to issue a B1 waiver, that authority resides with you. But FYI, OGE is not fond of B1 waivers for negotiating for employment, and we've been very sort of public about that.
Well, I think that makes a lot of sense, because when we look at the B1 threshold, we have to determine that the financial interest is not so significant as to affect the integrity of one's service.
Right.
And your employment is a significant part of your financial life.
Exactly.
With very few exceptions. For most people, that's a very significant, who pays, who you receive your paycheck from is a significant part of your financial life, almost no matter who you are. So I think that's maybe the reason that we take sort of a very cautious view here.
Yeah, we do, and it's precisely that. It's the overcoming the interest is not so substantial. We think it's a very difficult hurdle to get over when you're talking about the person's prospective future employment. That's a financial interest. That's a pretty significant financial interest. The other thing too, though, I do like to remind folks is that we aren't just looking at the employee's own financial interest in their future employment. When they're negotiating for employment, it's the financial interest of their future employer that is also their entire financial interest is attributed to the employee. So you have to look at, what the future employer's financial interest is in the matter, in addition to what the employee's own personal interest is in the prospective employment.
So that there's a reason
that's a deadly combination to have to overcome to establish that the interest is not so substantial to affect the integrity of their services. So that's why OGE does not look terribly favorably upon these types of
It's just difficult to meet the threshold. I think it's playing on the face of the requirements.
Yes.
It's just tough to get there.
It is. Very hard. Okay, so now we're going to move on to what will be our eighth and final statement, which is there are no meaningful differences between the requirements in Subpart F and those in Section 17 of the Stock Act.
Oh, how some of us wish this were true.
That it was just purely redundant. It was just completely redundant. Knowing one was tantamount to knowing the other. That would be wonderful. But it is not so. 'Tis not so. That is fiction. We have given you a job aid that we've created, which kind of breaks down each of the requirements, those under Subpart F of the Standards of Conduct. and those under Section 17 of the Stock Act. And it's a beautiful little, well-formatted thing which you can use as a job aid, but I couldn't quite fit it all on a screen that would make it easy to read. So I came up with my own, and this is the final slide, I came up with my own comparison of the two. And basically, what we're looking at here is Subpart F of the Standards of Conduct applies to all employees. So any employee who is deemed to be seeking employment, as that is defined in Subpart F, is going to have a disqualification requirement under Subpart F, and then under 208 if they proceed to negotiating or have an arrangement for prospective employment. Under the Stock Act requirements are only going to apply to public filers. So that's a subgroup of all employees. So we're really only focused on there are people who are filing public financial disclosure reports. Subpart F, as we've been discussing, is a recusal requirement. It's a disqualification requirement. The Stock Act, by contrast, has both a notification requirement as well as a recusal requirement. And if you look at the notification requirement is that within 3 business days of commencing negotiations or agreements of non-federal employment or compensation, the employee is required to file a notification regarding was required to file a notification of the fact that they've commenced negotiations. They're also required to file a notification regarding recusal if there's a conflict of interest or the appearance of a conflict with respect to the non-federal entity with whom they're, that relates to the notification statement. And then obviously they have a requirement to comply with any recusal requirements that they have by virtue of the situation that they're in where they're negotiating and it presents a conflict or the appearance of a conflict. So it's both a notification requirement within 3 days of undertaking negotiations, as well as a recusal requirement if the entity with whom you are negotiating presents a conflict or the appearance of a conflict. One thing I do want to say about the notification requirement, and this goes back to what Patrick and I were talking about a minute ago, the definition of negotiation is the one that we use for purposes of 208, is the one that's in Subpart F, and it's a rather porous definition. So what I know for a fact some agencies are actually doing and have been advising their employees of, and at least in our proposed changes to Subpart F, we also make this suggestion, is that employees actually file their notification statement in advance of negotiation. So I know there are a lot of agencies that, rather than using the negotiation as the triggering, are encouraging their employees to do it when they begin seeking.
And that makes a lot of sense, because we want to provide our employees with the counseling that applies to the seeking provision before they start seeking. So, the earlier we can provide that, and if while we're doing that we can receive the notification as well, all the better.
Right.
Right.
Right. So just, sort of a heads up to those of you who may not be doing this, that it may be something that you want to consider advising your employees that they should do, is says, out of an abundance of caution, to not wait till they're actually negotiating, but actually do it in advance of negotiation.
Right. Because, it does the same thing as Subpart F. It prevents us from needing to draw those fine lines and engage in that exercise of determining, well, is it merely seeking or is it technically negotiating at this stage?
Right.
We could just say, look, you're looking for outside employment, let's file the notification.
Right, exactly.
Yeah. You have to recuse anyway. Right.
Right.
It makes a lot of sense.
Right. And that gets to our next bulleted point, and I want to make sure that everybody understands what the actual legal requirements are, over and above what our prudential, advice is. The legal requirements under Subpart F, the triggering event is seeking employment. And as we said earlier, that's
concurrent with or after government employment.
It's
right?
concurrent with or after government employment, but also the fact that it's the minute you make any contact,
right.
Initial contact with respect to prospective employment. For the Stock Act, the triggering event is negotiation or arrangement for employment or compensation. Now, this is where the Stock Act is going beyond Subpart F, because now it's looking not just at an employment situation, but a situation where you have a negotiation or arrangement for the receipt of compensation for the provision of personal services. And we see where that could come up in a situation that's not technically an employment situation, might be in the situation of like doing teaching, speaking, or writing, where there isn't a formal right. employment arrangement,
Right, or one of those other named arrangements under subpart F.
Right.
Right. So it might not be consulting but it could be something that's not one of those listed things in F, but is still compensatory in nature. The Stock Act still applies.
Right.
So we have mostly overlapping but slightly divergent circles of influence.
Exactly. And it's just important to realize that the Stock Act could very well reach beyond what we commonly think of as seeking employment under subpart F.
Right.
And then finally, as Patrick pointed out a minute ago, under subpart F, it's if the employment is concurrent with or post-government employment. But under the Stock Act, it's only whether the employment or the receipt of compensation would be in a post-government capacity. So we're looking at anything that happens after you terminate government service.
Yep. So that's clear.
That's, pretty clear. And we've given you a copy of the legal advisory that was issued with respect to that, and that really I think helps to try to explain the distinction between employment and compensation to the extent that we had some concrete examples of that. So we've given you a copy also of that legal advisory that I would advise you to take a look at. But in some, we've got, varying authorities that are controlling what employees, have to be mindful of when they're looking for employment. Again, that's either just an outside activity or that could terminate their federal employment. And as ethics officials, we just kind of have to be on top of all of these various and competing authorities so that we can make sure our employees are aware of and are complying with all of them simultaneously.
Yeah, and I think, when you're advising your employees, a good thing to do is just take them one at a time. Do your analysis under the Seeking Reg, do your analysis under 208, do your analysis under the Stock Act. They're separate analyses, they have slightly separate criteria. So, accept that and just be methodical to go through each of them in turn.
Mm-hmm. So that's all we have for you today for Seeking, Negotiating, and the Stock Act.
Excellent.
Again, if you have any questions, please don't hesitate to email either Patrick or myself.
We'll be happy to answer them.
We will be happy to answer them.
Excellent. Well, thanks very much for joining us, Cheryl. I think this has been good. Hopefully we have brought some clarity to what can be a confusing topic.
Yes.
And again, we'd like to thank everyone for joining us for the Fundamental series. We'll be back next month as we usually are. Also, we hope you will join us next week for the Advanced Practitioner series where we'll be discussing best practices for instructors of ethics training. And join us for the Post-Employment Massive Open Online course, July 20th, 21st, and 22nd. So thank you again, and we look forward to joining you from our new studio next week.
Thanks very much.
Thanks.